Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It's Friday, April 4th, 2025 at 1 o'clock in the afternoon. We're going to finish up our day and finish up this week. Continuing discussion on S-117, enacting rulemaking on safety and health standards, technical corrections on employment practices and unemployment compensation. And we're also adding workers' compensation into the bill as well. So I think that's probably right where we'll start is on the worker compensation side. So Ellie, if you'd like to join us.
Am I first?
Yeah.
Oh, okay. Thank you.
We'll have, we'll talk to Sophie at the end, in case there's some other changes that we'd like to see. And
Sure, thank you. I'm Kelly Massicott. I'm a practicing attorney here in Vermont, in Montpelier, and I'm with the law firm of Bigham Fox Skinner. And I'm also here on behalf of the Vermont Association of Justice. The provisions that were included in S-125 are very important for injured workers, and there's four main points here. The first one has to do with medical case management services. These services already exist in the law. Actually, they're outlined in the rules, the workers' compensation rules. To be clear, case management services are not medical treatment. They're the coordination of treatment. They're basically to try to help injured workers through the medical recovery process easier and to help them kind of cut through the red tape, basically. Help with coordination of specialists and getting pre-approval and things like that. Right now, insurance carriers are the ones who decide whether these services are warranted in any particular case. The proposed addition to the definitions under 21 VSA 601 would grant claimants, injured workers, entitlement to these services if the evidence supports it. I'm working on a S-125. Is that okay? Or should I be? Okay. So in that bill on page 2, lines 13 through 16.
yeah, can you just give us a section? And
Oh, sure. I'm sorry. Yep.
Doing 125?
actually, yeah, if everybody works off of 125, it'll work better.
I apologize. I know you were talking about adding it to another bill and
We added it into 117, but we can look at 125.
I'm on S-125, section 1, page 1. It starts at, it starts at line 5. So again, in the definition section, it outlines the definition of medical case management. This definition already exists in the workers' comp rules. So it's just repeating that definition in the statute itself. And then on page 2, lines 1 through 4 is the new language, which is where it explains an injured worker shall be entitled to these services if reasonably supported. And the proposed language is reasonable support includes a recommendation made by a healthcare provider or evidence demonstrating the injured employee's medical recovery would benefit from the services, or both. I want to be clear, in the vast majority of cases when these services are needed, the insurance company is assigning medical case management services. But there has been claims, my law partner had one, with a gentleman who had very low IQ. He lived alone. He didn't have a spouse that could kind of help him or a friend that could kind of help him understand this process and support him through it. He'd actually had a prior stroke prior to the work injury. And she went to the Department of Labor because the workers' comp carrier refused to assign a medical case manager to help this gentleman through the process. And the Department of Labor said, sorry, we don't have the right to order these services. So we're trying to add this language in so that in those kinds of cases where the carrier is not willing to assign a medical case manager, an injured worker can provide the evidence to support that it would be appropriate to have those services. I did see that the insurance side is suggesting an amendment to this. They want to take out the language about other evidence demonstrating that that the claimant or the injured worker would benefit from the services. They would like the amendment to limit it to just a recommendation by a healthcare provider. I really urge you not to take the amendment. We need both sides of this. A healthcare provider recommending it is important, but it's also important that there might be other evidence other than a healthcare provider recommending it. Let me give you an example. A lot of folks don't even have a primary care provider when they get injured. They have a bad workers' comp injury or bad injury at work. They might be sent to the ER. They don't even have a PCP to follow up with. They need somebody to help them coordinate all these specialist appointments, getting into physical therapy, following up with the surgeon. So to think that they can get a treating provider, who is that? The ER doctor they're never going to see again? To think that they could get a treating provider to provide that opinion to support the need for those services isn't reasonable. There's other situations too where the evidence may warrant support of these services. For example, as I said, a person with lower IQ or other cognitive or psychological challenges, the person that lives alone and doesn't have a support system. These are folks who really benefit from these kinds of services. So it's not just, hey, I've got a doctor, he knows me well, or she knows me well, she knows and she can write this opinion for me. There's definitely other cases where it's not going to be realistic to expect that there's a treating provider to offer that opinion to support the need for these services. So I urge you not to take on that amendment and to keep the language as it is right now. On page 2 of S125, starting at line 5, section 2, this is subsection D, which is from lines 8 to 11. This has to do with ensuring that folks who don't speak English fluently have access to translation services throughout the workers' comp claims process and for the medical appointments that they have. Again, comp carriers often do pay for translation services already, but not all the time. We need to make sure that folks who are injured, who are going through the workers' comp system or are seeking out medical treatment, that they have access, equal access to all aspects of the medical and legal framework in the comp system, and S125 as it's written will ensure that. Section 3 of the bill, which starts on line 12 of page 2, this flips back to the medical case management issue. This section 3, which goes on to the next page and also goes on to page 4, this is simply a process by which the injured worker can request those services pre-authorization. We already have this pre-authorization process for medical treatment. My client needs a surgery. There's a process by which we ask for pre-approval by the insurance company. It allows the insurance company an opportunity to hire their own expert to gather evidence, and they can agree to pay for it, or they can object and say, no, we're not paying for this, and here's why. And the Department of Labor is the one who ultimately makes the decision. So the language is just copied. There was just a discussion I had with Dirk Anderson from the Department of Labor. Perhaps this could be simplified instead of adding 2 more pages of all of this language and making the statute that much longer. Perhaps it can be combined with the existing language. I was just being careful about when I suggested this. We have certain benefits outlined in the statute. This is a service, technically not the same. So that's why I had suggested maybe it needed to be on its own as a service. But I'm certainly not opposed to it's the exact same language, including this same language under the pre-authorization for benefits and just having service and benefits together. Again, it's the same process that would take place whereby an injured worker has a procedure. They can go to the Department of Labor to get pre-approval for these nurse case management services. Then we move to section 4 on page 4 of S125, which starts on line 17. And it goes on to page 5. This has to do with the penalty structure when an insurance carrier issues untimely indemnity payments to an injured worker. This is not all payments made to an injured worker. Injured workers get reimbursed for mileage when they attend medical appointments, or if they happen to pay for a prescription out of pocket or a brace or something, they get paid back for that. It doesn't apply to those kinds of payments. These are the wage replacement benefits that an injured worker is due if they're out of work because of a work injury. It's like a paycheck. They're depending on this money every week, or if the employer pays biweekly, they get their indemnity payment every 2 weeks. But injured workers, many of them were already living paycheck to paycheck before the work injury. Most claimants in the workers' comp system are receiving 2/3 of what they were earning prior to the work injury. Money is so tight for these folks. They're not always getting their payments on time. There's a rule, it's written on the form. What day is this person supposed to get their direct deposit? What day is this check supposed to go in the mail? I can't tell you how often it happens that I'm getting a call from my client, the direct deposit didn't show up today. I always get it on Tuesdays. It's not here, it's Thursday. I can say I've been doing this almost 20 years. It's increasingly frequent that these payments are not being made on time. I had my paralegal look through my own cases, and since January 2024, out of, I believe it was 64 cases where my clients were due indemnity payments, there were 47% of the cases since January 2024 where there was at least one payment late. 32% of the cases, there were at least 2 late payments. And 26% of the cases, I had a client who had at least 3 late payments. I did talk about these are wage replacement benefits. That's the vast majority. That's the temporary disability, we call those payments. That is like a paycheck for those folks. It's replacing their wages because they're out of work due to the work injury. There's another type of indemnity payment called a permanent impairment benefit. But it most commonly happens with these wage replacement benefits. The current penalty scheme allows for a 5% penalty of the amount. If the payment is late, up to 20 days late, the carrier owes a 5% penalty. Doesn't matter if it's the first time, it doesn't matter if it's the 10th time in the claim. If the payment is more than 21 days late or more, it's a 10% penalty. The proposed language here would call for a 5% penalty for the first time it's late, a 10% penalty for the second time it's late in a claim, and a 15% penalty for the third and every subsequent time it's late in a claim. You may remember that this language was actually in a prior bill a couple of years ago, and the penalty scheme at that time went up to 20%. This bill, S125, when it was over in the Senate, the penalty scheme actually went up this year all the way up to 25%. It's that desperately needed, folks. I mean it. It's that desperately needed. They made the decision to cap it at 15. That's what you're looking at here. I still believe 15 is too low. The current penalties at 5 and 10% are certainly no deterrent. This is happening all the time. It's not just one bad apple, one insurance company doing this. It's happening over several insurance companies, and it's happening with increasing frequency. I keep mentioning I have one claim where there's been 25 late payments over the course of a couple of years. That one might be an outlier, I'll admit it. But the statistics I just gave you, 64 cases and 26% of them had at least 3 late payments. This is not okay. These people cannot afford. They're getting bank fees, return checks, they're missing rent, they're missing their mortgages, their car payments. They don't get payments or money compensation for those extra fees they're incurring. They get the 5%. Unfortunately, there's not good data. The Department of Labor is not in a position. They're not aware when these late payments are done unless myself or another colleague is squawking and saying, hey, this is late, and they're not refusing to pay the late fee when I ask them to pay it. Please order them to pay it. So I know the department is aware of this problem, but they have no idea. They don't have the data. They just don't have the ability to monitor or track this data to know how extensive it is. But I can tell you that it's very extensive and it's happening with increasing frequency. So we really need to, this time, please pass this with a higher penalty scheme. I would urge higher than this 15% that the Senate looked at, but we really do need to do something to change this because Vermonters can't, it's an untenable situation for my clients. And I can't even imagine what's happening to unrepresented injured workers out there who might not be aware that there even is a penalty or what their recourse is. I would like to say one other thing. It's not part of the bill, but something else just came up that has come up over and over again for me. Every couple of years I hear about it. I'm like, ooh, this needs to be corrected. And I just want to make a pitch here. It's not part of the comp statute, the workers' comp statute title. It is in Title 21. It has to do with unemployment. Folks who are out on workers' comp may eventually have to apply for unemployment. They cannot get those wage replacement benefits at the same time as unemployment. Obviously, that would be double dipping. They can't be entitled to both at the same time. But towards the end of their claim, if they don't go back to that employer, maybe their injury has left them in a place where they can't do that more physical work they had been doing. They might qualify for unemployment down the road. And the unemployment statute does not penalize them because they might have been out of work for 2 solid years. They are allowed to apply for unemployment, and if they otherwise qualify, they can get those unemployment benefits based on the wages that they earned prior to the injury. That's wonderful. That's very good policy. Where there needs to be a fix, though, is there are some folks who work part-time while they're recovering from their injury. Right now, those part-time wages, and we call this temporary partial disability when somebody is still recovering and earning a little bit of money working for their old employer and getting a supplement from workers' comp and wage replacement. Those reduced wages are being included in the calculation for unemployment because some gross wages were earned. It's really unfair. Now, if all the injured workers were earning close to what they had been earning, if they're working 35 hours, I wouldn't be complaining. But I have clients who are going back and working 5 hours a week, 10 hours a week, when they used to work 40 hours a week or overtime, 50 hours a week. Imagine what their unemployment calculation looks like if part of the calculation includes 6 months of working 10 hours a week. We want people to be working, especially when they're recovering from a work injury. All the studies show people who are getting back to work sooner, if they're engaged in work, they're going to do better overall. But this is not a great situation where they might have to look to unemployment for a short period while they're transitioning to a new career or a new job at the end of their comp claim. And they find out, and I had a gentleman, he found out his unemployment benefit was going to be under $100. He couldn't believe it. And then we realized why. It's because he worked for an extended period at that less than 10 hours a week situation. So I'm sorry, I don't know the unemployment statute well, and I'm sorry I'm just bringing it up right now, but it is something that I hope can be addressed at some point because the wages earned by an injured worker while they're on temporary benefits in a comp case should not be included in the unemployment calculation. That's my pitch for another fix. Anyways, I'm happy to answer any questions or explain anything about the comp system that I'm able to. Folks have any questions?
Mr. Kelly? No?
In the one of the earlier points you made about not limiting a recommendation from a primary care.
Not, yeah,
So which would expand the circle to what sorts of, from whom could such recommendations?
It might honestly not even be a person. It might be, I have evidence that the person never graduated from high school, had an IEP, has an IQ of, high 50, 60 something. Had a sheltered job, lives, has a ton of challenges. Can't manage these appointments on their own. A lot of these nurse case managers actually attend appointments with people and help them understand, this is what the doctor's explaining your options are. This is what this means. This is what that means. And so it might not even be a specific person writing the recommendation. It might just be presenting certain evidence about why these services would be warranted.
Is part of the thought that, as it says, that reasonable support includes a recommendation made by healthcare provider or evidence demonstrating the injured employee's medical recovery would benefit from the services, or both in that, or et cetera, or that is that also tied to healthcare providers, or is that?
No, it can be outside of the healthcare provider.
All right.
And it could be, let me be clear, it could be, we have somebody with a real complex work injury. Boy, they've got a bunch of specialists. There's a lot going on and they need assistance. Or it could be this person, before they were ever injured, had a bunch of challenges, but they were on their own and working. And now they're dealing with a major work injury, or not even major, but a work injury. And because they're low intelligence or they have other challenges, they're not well equipped to deal with this. And the truth is, comp carriers generally support these services because it saves them money. Yeah. We all want the person to get through the system as quick as possible and recover to the best of their ability. And so having that support benefits really everybody. And I don't think this is a big controversial topic. I do see the proposed amendment about it, but I just don't think that the insurance carrier side has necessarily thought about the other scenarios where the person that might have the cognitive or socioeconomic challenges could also really benefit. I mean, I've had a client who I think his intelligence was fine, but he had real social anxiety, didn't live with anybody else, didn't have a friend or family or anybody to talk to or to attend appointments. He really did benefit from these nurse case manager, or that's also what we call it, medical case manager, or nurse case manager services, attending the appointments and kind of keeping tabs on him, right? Like, don't forget your physical therapy is Friday and we're going to do this when we meet at that appointment, kind of thing. And it really is a benefit for all the parties, I would say. Yeah.
Can I ask what the schedule is for this bill in terms of taking it up? I was going to ask a question around that fix that I heard the witness say, and I don't. What's that?
On the UI.
Yeah, and but if we're on a sort of schedule, I can certainly
I
wait
think
till
that's
late.
something that we'll need to talk to the department about to
Right.
better understand what the underlying federal
Right.
law or what the feds say. If
Okay,
it's
it can
something
wait
we
for
can
that.
do, and maybe we can have that conversation later. Either with have Sophie,
Okay.
see what we can do.
Super thing.
It's kind of like an earnings disregard, but
Yeah, and I apologize. It was a conversation I had with a client. I'm like, ooh, this has come up again. It just, it does seem wholly unfair at the times when I do see it come up, that it makes sense that when somebody's out of work completely, they don't get penalized or faulted for that long period. That makes sense. I feel like it's the same, but I understand there's potential federal and other implications that need to be considered there. Yeah.
I have a question about the pre-authorization. I saw in here that it has kind of like a 14 days cycle.
Yes. So, and again, this is all language that already exists and applies to medical treatment. So the injured worker, or in the case of medical treatment, it's often a provider, is submitting a request with supporting evidence why this proposed surgery, or in this case, medical case management services, are warranted with supporting evidence. It's very, the rules are very persnickety about everything having to be all the T's crossed and I's dotted. once it's a valid request, the insurance company has 14 days to respond. And they can ask for another 30 days if they want to seek out an expert opinion and consult with an expert on it. Yeah.
Okay. Is there any concern about that, given that this is also presumably a time that a patient would be like in a kind of an acute medical need? Is this causing unnecessary delay to get them their treatment?
I love your question, and I would love that there be a shorter time turnaround time period. I agree. I suggested to piggyback on the existing language for treatment. The truth is the wheels grind slowly sometimes in comp. And so to me, trying to duplicate the existing procedure for treatment seemed appropriate. And let me be clear, this is not the process that needs to be used necessarily. This is only when I would informally ask the adjuster, hey, I've got this client, this is his situation, would you consider this? And it's only when they don't want to do it, they're fighting me back, that I would go through this mechanism. And because the mechanism is already there in place, and the Department of Labor case specialists are very responsive on this, and they're very good on these timelines and act quickly once the time is up. I guess I suggested it was probably best to just use this same process. And a lot of the time, it can be resolved after that initial 14 days. It doesn't always go to the full 45 that can be taken if they elect that additional 30 days to consult with an expert. But yes, I would love if it could be taken care of in like a week, or even a couple of business days would be nice.
48 hours, like.
No, I'm with you.
I'm just curious, the definition healthcare provider, is that defined as in Vermont statute anyway?
Might be a question for Sophie.
Huh?
Might be a question for Sophie.
It might be.
I am not as good as Sophie would be to
Yeah.
answer that one.
Okay. I'm just curious because I even searched it on the web and I got a whole bunch of different answers. And so I suspect that every insurance company is going to use which one they like best.
Well, and for myself as a practitioner, it's somebody who is actively treating my client, right? If I had a client who saw a provider 2 years ago who is no longer seeing my client, I'm not going to rely on that person. And the comp carrier, I would not consider that person as a, current healthcare provider, I guess, right?
And for full disclosure, that part of that arises to the fact that I am a licensed acupuncturist.
Mm.
And I've been refused because I'm not a healthcare provider. And I thought the definition, one of the definitions I found said someone who's licensed to provide healthcare services. I thought that was me.
In the implicit hierarchy of the medical community, I would still consider an acupuncturist a healthcare provider myself, but I would be,
Licensed.
Your license as a healthcare provider.
yeah.
But
Depending on what your issue is,
Yeah.
who you're using.
I guess I'm just wondering if it's in statute, so no.
In our workers' compensation law, section 601, sub 2, healthcare provider is defined as a person, partnership, corporation, facility, or institution licensed or certified or authorized by law to provide professional healthcare service to an individual during the individual's medical care, treatment, or confinement. So it's
Pretty broad.
pretty broad.
It is. And we, in workers' comp, I often have acupuncture services covered. So I certainly would, yeah.
Thoughts on how we obtain the data that we need to really understand these weight pain. The department is kind of set up the same way that the Attorney General's office is set up, that they don't know what's going on until they know. And the only way they know is if someone tells them. So we don't know if it's rampant or not. We have a shot in time of what you're experiencing. But I mean, I don't have a problem with adding penalties in. But in order for me to justify raising them to 25% or whatever as a deterrent, I need to know how bad things are. And so I'd like to try to figure a way of getting that data. And I'm wondering, and we'll have that conversation, I think, with the carriers, is self-reporting when they, and there's going, and I know I've been involved in this for quite a while. And I know there's issues, if it's direct deposit, there could be an issue with the bank so that they're not getting their funds right away. It happens. Same with the mail, we can't rely on the mail. And I guess also, and another question is, in your experience, how many of your clients are utilizing direct deposit opposed to a paper check?
I think direct deposit was a great change in the statute. I would say at least half, if not more, of my clients. And by the way, I don't look at the mailing at all, and I tell clients that. By the way, my mail here in Montpelier is absolutely horrible. I've counted, we've been keeping track, and we did not get mail for 15 in the last, whatever, how many mail days, 24. Did not get mail for 15, got mail for 9. And these, I'm waiting for checks for clients, settlement checks, and other important, Form 27s. I want to cut off my clients' benefits that happen automatically if I don't respond. So the mail is awful. I go by, the carriers have printouts that show the issue date. So I'm assuming they drop it in the mail on the issue date, which frankly, I don't think actually always happens. So I'm not even looking at the delays that can happen by mail. I'm looking at their printout issue date or the deposit date. A lot of the carriers now do have portals that also clients can sign in, or they give us permission, we can sign in and check what the issue date. So taking the mail delivery problems out of it. I think self-report is not a great way. I've got to be honest. There so many claims. A lot of them adjusters don't even realize it till I point out. I mean, they're very busy. They got a ton of claims. They're not even aware of it. And they may say, oh yeah, okay, I'm putting them back. I'm putting them back. Yep, I'm going to catch them up. I have to say, and issue the late payment. They're not recognizing that they automatically owe. And the statute, the existing language says shall, it's mandatory, but they're not doing it unless I'm pushing them. And then I sometimes have to go to the Department of Labor. I don't think self-report is a great mechanism. I said to Dirk, maybe last year, hey, call 10 of the defense attorneys and say, off the record, how often are you hearing from claimants attorneys or, unrepresented folks about late payments, and I bet they would say every single week.
We can't.
I don't think there's a number, it would be quite a project, right? It would be quite a project to ask an insurance carrier, give me 100 printouts of anybody on TTD and then scouring over them to look at them. I do pretty much only workers' comp, and I don't think my statistics are somehow unrepresentative, because my claims are not just disputes and battles. I have claims that things are going fairly smoothly. They're just big claims where people need the assistance to make sure that they're getting the right advice and things are, they're getting the benefits they're entitled to. So I don't think my statistics are outliers. I don't have a good answer for you, unfortunately. I'm not sure.
I'm just wondering if the law community, are you often involved with workers' comp cases?
Oh, it's pretty much all I do. Yeah.
I'm wondering if you're the data point.
Well, that's what I'm saying. I mean,
You already have it.
I produced my data. If I said to my, I mean, what I really don't want to happen is we're not passing this year, come back next year, Kelly, with some data. Please don't do that to us. I hear what you're saying, sir, which is, to go higher, I need justification, right? If I said to my colleagues, hey, you need to start keeping numbers like I have. My paralegal's amazing, and she brought up all these numbers, like she had the data. If we asked other colleagues to do this, I'm sure they could. And maybe that's the evidence you need in the future to justify after a change up to 15, going to 20 or 25. But I beg you not to keep the penalties where they are. It can't be another year, 2 years, 3 years of the 5 and 10. The problem's getting worse and people are really suffering.
Many, just if in your experience, and you may not be able to answer, but how many people that are on workers' comp have an attorney?
I don't know that, but Dirk may have an idea. Oh,
Dirk Anderson, Department of Labor. Process is generally, if you're injured at work, your employer files Form 1. It goes to the insurance carrier. If it's, in most cases, if the claim is accepted, there's no reason to get an attorney. So those claimants do not. And then if they start experiencing late payments, they're probably not going to go get an attorney just for that. But what percentage of all comp claimants are represented, I really don't know.
well, and a claim is anything from, I had one urgent care visit and lost no time from work to I'm permanently totally disabled and never going to work again, right? I mean, it runs the gamut. So I'm sorry, I have no idea what the percentages are. Certainly folks who are on these wage replacement benefits, these temporary benefits, and there is some data about that, but I would also say there's a lot of people who are receiving those wage replacement benefits where there isn't an approved Form 32 on file necessarily. So I don't know them. Unfortunately, don't have a good sense of that.
On that, I mean, as far as your clientele, are they typically people that just at the outset, I've been injured, they come to you and say, need you to help? Or are we more dealing with people that are tried to deal with it on their own, got frustrated and said, hey, I need some extra help, and that's when they bring you in?
It's usually that. Every once in a while, there's the catastrophic injury where a couple of weeks in, they've got friends or somebody saying, this is too big. You need to have somebody helping you during this process. A lot of the time they're doing it on their own. And frankly, several times these late payments keep happening, right? I mean, honestly, if I was self-interested, I wouldn't even be here because I probably get work because of these late payments, but it's not right for injured Vermonters. The late payments is one of the reasons I do hear from people is I just don't get them consistently, you know? It's late, it's a week late. I mean, can you imagine going 20 days without a paycheck? And then you're told that, oh yeah, they owe you $24.89 because of that. That's what I have to tell people. And I say, I know you're frustrated. That's the law, unfortunately. It usually is people try to go it alone until they start facing issues with something not getting paid, or my doctor says I need this surgery and they're not approving the surgery. And there is this whole pre-approval process that a person who's unrepresented doesn't understand how to maneuver this process. And a lot of folks who may understand, I've had a work injury and I'm not going to go back to this job I've had for the last 30 years. What does that mean for me? That's the other category of person that wants to consult often with an attorney. And obviously denied claims, denied surgeries and things like that.
It would be really great if the department's notified every time there's that you see, and I'm trying to figure a way. I mean, even if we get partial data, will show us that there is an issue or not.
After this, we first brought this up 2 years ago. I think there was testimony or there was a comment like, this is very rare from the insurance type. Maybe only happens 2 or 3 times. And poor Dirk, at the beginning, I was forwarding him all my emails every time I was emailing a case specialist. And Dirk said, oh, there's the 2 or 3 times in like a week or 10 days kind of thing. So I'm telling you, I'm keeping data and mine is not unrepresentative. I don't have some special group of cases where they're just deciding to pay my clients late for some reason. This is a widespread problem. If Dirk just, and again, it's anecdotal, but the workers' comp bar is a small bar. And if you were to chat with workers' comp attorneys on either side, and I can tell you, defense attorneys don't want to spend their time chasing down late payments, right? That's not why they went to law school either. They would like to be working on the serious substantive legal issues. But if you ask them off the record, they don't want to throw their clients under the bus. They don't want to throw their insurance carrier clients under the bus. But if you ask them off the record, what's up with late payments? Are these happening kind of common? They're going to say yes. They're really common. It's happening a lot, and it's happening with more frequency.
When you take on a client, who's paying the bill?
I work on a contingency fee basis, so I earn a percentage of what I help get them down the road. I don't take a fee on those wage replacement benefits, for example. It's really on like permanency benefits or if there's a settlement down the road. But as I tell my clients, settlement is not necessarily a good, these claims can remain open. And for some people, it's not a good idea to resolve the claim depending on how their injury may progress and affect them down the road and their ability to work and earn a living down the road.
We have another deterrent.
Well, right now it's the penalties, and there is something called administrative penalties, which I know folks have made the requests to Dirk Anderson, and he's issued some. Dirk's got a ton on his plate, and I know that there's several pending with him. He hasn't had a chance to get to, I don't think, but that money, if it's awarded, it doesn't go to the injured worker, right? It goes to the Department of Labor. So my client who's gotten 25 late payments in his case and is absolutely frustrated and doesn't understand how this is possible that this can keep happening. If administrative penalties that I've requested are awarded, it doesn't go to him. And honestly, I don't need attorney fees for it. I need my guy to get paid on time. That's what I need. I need him to get his payment every week, just like he would be getting a paycheck from an employer every week. That's what I need. And I need a deterrent that's going to stop this from happening. And the 5 and 10% is just not enough.
Well, I'm thinking, if they have to hire a lawyer in order to get their back pay, that attorney fees need to be covered.
I think the difficulty with that is somebody hires me now because their payments are coming on time. My fee may not come for 2 more years.
But you're expending time.
Oh, sure,
Right, so that time is worth something
sure. But that's not,
in order to get them.
money, like that's extra money for me, fine, great.
And that's fine. And
Yeah.
The other piece of the penalties going to, maybe some of that needs to go to the worker as well. Especially if it causes them to overdraw their checking account, if it causes them to be for late payments on other things. Then, those are the types of things that we need to think about. And so.
Yeah.
I think we're gonna have some more work to do on this and try to figure out how we stop the practice from happening. And make sure that if it does happen, there's deterrent, and make sure that the worker is made whole as much as possible. If there's any other issues because they didn't receive their pay.
Penalties and coverage of, their banking fees would be wonderful. Absolutely. Yeah. I really appreciate, yeah, I really appreciate
Right now,
this.
we're hearing one side of it, so we'll hear the other, of course.
Yeah, absolutely. And one thing I would say is if you hear this isn't really happening a lot, or this is only like maybe a couple of bad apples, what's wrong with instituting the penalties? I don't believe it. I don't believe it's true. My experience tells me it's not true, and that of all my colleagues, but then what's the harm with instituting the stiffer penalties? That's my response to that. Yeah. I really appreciate all of your attention on this and your consideration for these things. Thank you.
Amy?
Good afternoon, Mr. Chairman, members of the committee. Jamie Fian with Primer on behalf of the American Property Casualty Insurance Association. APCIA is the preeminent national trade association for, you guessed it, PNC companies writing PNC lines, including workers' comp. Collectively, they write about 70% of the market of Vermont, including in the workers' comp space. I'll here to speak to the three provisions contained within the bill related to workers' comp. The first two, and I'll just go in order of the bill as they appear, are to codify sort of existing practice related to medical case management services and translation services. I think I'll start by sort of saying, I don't want the committee to get the impression that this is a contentious area, because it's not from my perspective. I continue to hear from insurance companies that, whether it's case management services or translation services, these are tools that are available to help the injured worker get back on the job as quickly as possible. So it's in the best interest of the employer and the insurer to utilize these tools or others that are at their disposal to help to do that. So, I think the issue here is, you're sort of seeing a statutory framework put into place, but I haven't heard of any particular issue from APCIA and their members that this is a contentious area, again, because it's a tool to help the injured worker get back onto the job. And, these are nurse case managers. They're almost by default, one is applied in indemnity cases, and sometimes when it makes sense in medical only claims as well. So they're widely used now in Vermont, will continue to be widely used. This sort of cements what's in regulation, but it also allows, as you've heard, the injured employer or employee to request the services on their own and not wait to have one applied, by the insurance company. In that vein, because it is sort of, a framework in statute, APCIA did recognize one area that would like to draw to your attention that we think could use some clarity, and that is in this area of reasonably supported. Under, I believe the name Jonathan Schreiber on your committee page today is APCIA suggested language. The problem or concern that APCIA sees with this particular section is that reasonably supported or reasonable support is not defined, but it includes examples in this subdivision C. And those examples are but a couple, but of course could include others. We look at this as sort of laying the base work or the foundation for which to have the conversation about case management services. And our preference would be to have that initial determination be determined by the medical provider solely, and then have the conversations follow that. So if the medical, because again, this is an entitlement according to this proposed language, if the medical care provider, as we know now how they're defined, recommends that case management services are, should be in place, then boom, we go from there. And if there's a necessary, requirement or step to then employ the framework 14 days or whatever thereafter, that will be in place. It doesn't preclude at any point, whether it's the injured employee, him or herself, or counsel from saying, hey, we think the medical provider missed something here. Would you consider, using case management services for this particular reason? In addition, the statutory framework allows this additional information to be brought to the commissioner's attention as well. And they can either overrule or rule on their own behalf, whether or not to use case management services. So we ask you to consider in terms of clarity's sake, because we do think that those examples are subject to different interpretation and may create a little bit of, well, confusion. We'd rather have it just start with the recommendation of the healthcare provider.
What we heard from Kelly, somebody, a worker's injured. They go to the ER, doesn't have a primary, is told that they need to go see a doctor. They're not savvy. How do they go about requesting that if they don't really have an understanding?
I don't think any of this would preclude that conversation from happening as it happens now. It's an informal conversation between the injured employee and either their employer or through their employer, the insurance company, about, hey, I need some help to help navigate my claim.
How often does it happen that case management services are provided when the injured person requests them? Or when the injured person requests extra support?
I'm not sure. I'd have to
If you could get
check.
that.
Yeah, we'd have to check I don't know if.
If you're saying that
statistic.
it happens already, I'm curious how often it happens.
What I'm saying is they're already appointed and provided. It's really not a contentious issue. We'd rather just have it clear that it starts with the recommendation from the medical provider, and then we can introduce these other conversations.
Well, then I guess the number would be how many work comp happen that have case management services? What percentage don't?
Yep.
That would be helpful for.
I can try to get you definitive numbers, but from what I've heard from carriers, they're almost always appointed in indemnity claims, for example, which feature medical and wage component. And when it makes sense in medical, they're appointed there as well. But I can try to get some concrete numbers for you.
Jamie, I'm not quite understanding what your point is around proposing this different standard. Is the concern that you think that the existing language would preclude the carrier from, offering these services like I guess they do now? I'm trying to understand what the concern is about the current standard, which they have some examples, but it doesn't preclude other means of supporting the need for medical management.
Yeah.
I'm trying to understand.
Sure. I think it really boils down to lack of clarity. Again, there is no definition here. There is probably subject to different interpretation what reasonable support could mean or can mean. And we're just sort of saying, let's at least at the outset have it start with a recommendation from the healthcare provider.
I'm just trying. So what's the concern that you have around having it? It includes, but obviously it can include other ways of justifying medical management services. What's the concern for the carrier in that kind of sequence?
Well, there could be a proposal. I mean, that is most elemental proposal from the injured employee that may not make sense. But again, I think under the structure, perhaps that could be considered, by the carrier.
Okay. But in any case, it's all subject to DOL's
It is.
jurisdiction.
It
Seems
is.
like that you have a pretty close handle on that sort of stuff.
As often happens in a regulatory environment, the regulator has a close handle on it.
Well, even more so than in some other. Okay.
Yeah. I mean, again, if you look at the structure that's in place, I'm working off a different draft, and I apologize, like others. The very last provision says if the insurer fails to authorize or deny the services, the injured employee or their treating provider may request the department issue an order. And so the department will consider all the evidence. Beyond that,
Right.
next section under G, if the insurer denies, the department can act on its own and not even wait for someone to request.
And that's why I'm just having trouble understanding what the concern of the carriers are. I should.
We just think, clarity always helps. And Same is true. Again, no comments on translation services other than they are already provided where it makes sense and don't have an objection to this piece being in the bill. Which brings me to the late fees. Here we have a difference of opinion. I continue to hear from APCI and their members that late payments are rare. And when they are happening, not only late payments are rare, but that, department orders or fines are similarly rare for this issue. And further, when they do happen, they tend to fall into sort of, I'd say, two buckets. The first would be kind of an IT or logistical error where, there may be a typo on the account and so the payments bounce back. There may be inconsistent, hits on the account for whatever reason. The injured employee may fall off a repetitive payment schedule and have to be put back on. So these are sort of under the control of the carrier, and when quickly identified, are quickly rectified as well. The other bucket would be for issues that are beyond the control of the carrier. For example, an employee has to provide a pay stub, if they're receiving temporary partial payments. There may be some medical appointments that are taking place, and we're waiting for information coming from those appointments, and it may be an issue of timing with respect to the schedule of payments. So there are some instances where it's really not necessarily under the control of the insurer, may result in the late payment. So when we talk about fines and increases and whatnot, the concern we have is, we do our best to make sure they don't happen, but there will be a human element. And particularly for instances where it's not under control, these proposed penalties nevertheless fall on the insurers. So, for those reasons, APCI opposes this. One of the things that we're all challenged when we see proposed legislation like this is you don't see the surrounding part of the statute. The commissioner has ample authority under existing law to do more. I believe someone mentioned attorney's fees or costs, and that's all part of the existing statute. That is a tool that's available now for investigation into late payments, as well as interest that can accrue on the sum unpaid. The commissioner also has the administrative authority, as was previously mentioned, to investigate and impose, $5,000 fines on insurers. Not only that, they could refer the insurer over to the Department of Financial Regulation for its own investigation, which has its own set of remedies, penalties, et cetera, all the way up to and including, suspension or revocation of license. I mean, obviously, something like this hopefully won't ever rise to that level. But there are numerous, I guess what I'm saying is there are numerous other provisions that don't show up here that show the powers of the commissioner. And I got to think a phone call or a letter from the commissioner to a particular company that happens to show up a lot, maybe on these late payments, is going to get a lot of attention by that company in terms of correcting any actions that may be happening. And, lastly, I would say, as has been raised several times, I certainly caution the committee to, make some policy pronouncements based on a lack of data. We've heard that this, you've heard this afternoon that there's a difference of opinion in how often this happens. It isn't tracked. I appreciate Ms. Massicott going through her caseload, but again, we don't know what was the purpose for those late payments. Which bucket did it fall into, for example? Is her caseload representative of the larger defense community caseload for this? The lack of data just to us seems troubling before we make sort of a pronouncement on an increased schedule of penalties. I volunteer APCIA to work with the committee and others to try to identify a way to perhaps find that data. I think the issue of reporting late payments to the department is worthy of further investigation. I mean, I think it, not only would identify the late payment, but what's the reason for the late payment, so we have kind of an idea of what that would be. And I think in another sense, it might even act as its own further deterrent or impetus for the carrier to kind of take a look at its own practices and say, well, I don't want to have to report this to the department in the first place. So I'm going to, if there are some instances, they'll take their own proactive steps to do so.
think, you know, the lack of the department finding any carrier, probably because they don't know. Right? So, of course, it's gonna, but and you're right, I think the commissioner has broad authority, and they also have broad authority to waive penalties if they find there's issues going on that they're beyond the control of the carrier, right? And there are, and I think we'll explore with the department more, you know, underlying, what else is in the underlying statute of penalties, and then, I mean, as you said, can get referred to DFR, and that can open up a whole other can of worms for a carrier, so.
So this has been discussed in the Senate for weeks, right? So the carriers could have gotten data for us in the meantime, even for the last month, to say these are payments that were on time, right? There has been ample time to come to us with some data to say, there's no reason for this. We're paying everything on time. You know, there have been these 3 cases in the last 6 months that something weird happened, right?
Unfortunately, has not been a several-month review by the Senate. This was a prior to crossover, introduced as S-125. Not a lot of time to.
Okay, but nobody's working on it. None of the carriers are so concerned about these late payments that they're pulling data together. I mean, it's computerized. It's not somebody going through files and pulling them out and checking boxes.
Again, all I can say is I've heard that it is rare and does not happen often. Yeah,
So if you could ask the carriers to provide us some
we
data,
can try to get it, sure.
that would
Yeah.
be really helpful. The hearing on one side, it's an issue, the other side says it's not an issue. We'd like some data that shows us something.
Jamie, one of the comments that I'd heard had to do with uncertainty around, you know, a claim, and there's that calendar issue you sort of mentioned. And in section 4, there's some language around when benefits have been awarded or are not in dispute as provided in subsection E of this section, which sort of gives a lot of reasons why there may be dispute. I was wondering if the example you brought up would be an example of dispute.
No, not necessarily.
So
It could be, again, maybe someone is on I'm just theoretical, 8 weeks of indemnity benefits. So the insurer probably programs whatever that particular day is into their system. If for whatever reason the continuation is extended, 8 weeks doesn't capture 9 weeks until they whatever that amount is. This is, one example.
Examples of a provisional or some sort of initial understanding, and the point of this process is that clarity emerges, and then a treatment program must continue. And that is it. So it is the case that communications are not instantaneous, determinations are not things that people just figure out immediately.
Correct me if I'm wrong, but it sounds like you're talking about case management and the payment issue at the same time.
Well, I think, okay, so maybe, well, I'm not really, that clarification would be helpful. I was just wondering if what you were describing was something that would be considered a dispute. And it sounds like what you're saying is that those are.
No, these are claims that are largely, they're not in dispute. It's just a matter of, did the payment hit the inbox in the bank, the account at the bank on the scheduled date that was chosen.
So I'm wondering, it just occurred to me, the carrier is regulated by DFR. Do you know if there's any enforcement history around that, around late payments, either complaint-based or market conduct or something like that?
I'm gonna hazard a guess and say no. This is sort of one of these dual regulatory arrangements where DFR is kind of like the premium side, the cost of insurance, setting rates, et cetera. And DOL would be the implementation side of benefits and et cetera, but I could be wrong. DFR does the licensing. DFR does the, again, they work with NCCI on premiums, et cetera.
I was just thinking the late payment, might be one, it might be one department.
It's one to see if, it's been transferred over to DFR because of such a, an egregious instance.
On the pre-authorization section, do you all have any thoughts or feelings about the kind of initial 14 days for response and the 30 days for review? Is that something that I think, given the potential severity of the situation with somebody being injured, would it be possible for those days to go down?
I could check with my client, but again, I would probably would prefer the existing proposal because it does mirror or match, a similar framework for other types of, for the benefits. For example, this is kind of copying what's already in place there. So when there's consistency, that helps, especially when we're talking about a structured framework. But I'll also check to see in, our experience, how quickly are these case managers, appointed from when a claim starts.
That'd be great, thank you.
Thanks again for the opportunity. Appreciate it. Look forward to continue working.
Finally get a chance to come in and testify.
I know, I've missed this committee so much. And I know I'm the last person between you and leaving for Friday, so I'll try to not dwell as much as I would like to nerd out on what we're going to talk about. But so William Driscoll with Associated Industries of Vermont, representing the manufacturing sector. Appreciate the opportunity to come in and comment. I think based on, with regard to what you've been discussing so far, I think we're generally supportive of the concerns and suggestions raised by Mr. Fian. So I just want to say that. The only other issue I want to touch on, you already heard a little bit from Commissioner Harrington. With regard to the department's proposals, the one in particular I'd like to speak to, or at least touch base on, is the change in Vermont's notice of layoffs provision, sometimes referred to as a mini Warren Act, after for those states that have adopted their version of what the federal law is. So the federal law is for companies with 100 or more employees if they have layoffs of 50 or 1/3 of their workforce, whichever is larger. There's a within 30 days, there's a notice requirement similar to what we have here, or an actual plant closing affecting 50 or more people. That was adopted in 1988. In 2008, California did its own version. And then Vermont did its in 2012, 2013. It was one of the things that AIV and the Department of Labor under Annie Noonan at the time spent a lot of time negotiating the details, working on a legislation introduced by a couple of legislators, including a young up-and-comer named Michael Marcotte. And we came up with what's in the statute now, which is basically 50 employees, layoff of 50 in a 90-day period, which is one of the issues, or a shutdown of 50. And then notice to the department, 45 days, ACCD, and then local authorities and employees within 30 days. That represented sort of a compromise. We're trying to, what would make sense for a smaller scale requirement for a state as opposed to what the feds were already requiring. And there were pros and cons with what we came up with. I don't recall at the time. I don't think there may not have been any other state other than California, or if there were, there might have been only a couple. Since then, there's about a dozen or so that have their own sort of rules. And honestly, I think there's some better thresholds or better standards in some of those states that would be worth looking at to adopt in Vermont. So the original proposal to simply reduce the number of triggering layoffs from 50 to 25, and then subsequently reduced further to 20. Our concern with that is it was really kind of exposing some of the big concerns about our current statute. It's a flat number. It's not this or a third of your employees, whichever is larger. And it's still over 90 days, not over 30 days, which is a little more common. So it really is a very sensitive trigger for what's termed a mass layoff. And it raises some administrative concerns and whatnot, especially as you look at companies that are, larger than 50 and getting up to like the medium or large size companies in the state. So originally our thought was if we're going to look at changes, why don't we look at some of those other states that have their own rules and maybe adopt some of those provisions, move some things around to take advantage of the best models that are out there. And in discussing it with the department, I know the commissioner in particular, I think, was interested in keeping it simple, stupid, rather than trying to think through the bigger issues. So I think, which we totally understand, and we can agree with that. I think it would be good to maybe in the coming year or 2 or 3 to take another look and maybe a more thorough reworking to reflect what other states do. But as you heard, I think the working idea that we're having there is keeping our existing baseline structure and add in the idea that if you have 25 layoffs or more as a single event, that would trigger reporting to the department. Not necessarily a public release at that time, but at least to get the ball rolling on providing people with services up front. And I think generally we're supportive of that concept. I think we still need to discuss further with the department about things like defining an event and whatnot. But I believe that there's language in other states that we'll be able to draw from for that. And I think the only thing I would add is, and we sort of flagged this with the department in the 80s, before the feds adopted their WARN Act, when this was an issue that was being discussed quite a bit, AIV and the state chamber developed a voluntary code, basically best practices of how employers should reach out to the state or whatnot if they know that there's a layoff coming. And I know AIV used to have an employer handbook that I think was still being circulated and used in the early 2000s. And that was one of the provisions that was laid out, encouraging employers what to do. I'm not sure what the chamber did to publicize it. But I think as technology and communication have evolved, I think that's kind of fallen by the wayside. It's not as front and center. So I think given, one of the things that folks are trying to accomplish is providing as much support for folks who are being laid off as possible. I think we're certainly committed to working with the department and with the chamber to see if we can try to revive that voluntary code and publicize it, get it more out there so that employers of whatever size and going through whatever layoffs can at least have that and be encouraged to be more proactive in working with the department on services. So that's not necessarily something that's needs to be part of legislation or anything like that, but just want to bring that up because that's the context. We're not trying to. It is important to try to get services to folks as much as possible, but you have to balance practicalities as well. So I'm hopeful. I'm pretty optimistic that we would have something that everybody can agree with next week or so.
So you're gonna take a look at what other states have done, put a proposal together, chat with the department and come back to it?
Yeah.
I don't anticipate this, I think next Friday scheduled. If we could, doesn't mean we're passing it next Friday, but we could have some.
I should note, I did flag this with the department that I do want to talk through a bit more the in-state, out-of-state size of the company, but I don't anticipate that being a huge contention. I just want to talk more about that.
Sounds good. Questions for Bill?
All right.
just to keep everybody here.
Let the record reflect it's not my fault.
Um, You go into a little bit the reasons why companies may not want to, or kind of leery about the Warren Act.
Yeah, and yeah, publicizing layoffs doesn't always make a company look good. Depending on what lead time is required for the notice, sometimes final decisions haven't been made, and if we start talking about laying people off before it's a done deal, it can hurt morale. It can maybe promote. Some people may want to leave. There are some reasonable exceptions in the bill, like, for if people are trying to secure financing, they definitely don't want to, show weakness of the company. But a lot of those exemptions are, I think, as a practical matter, you'd be going back after the fact, so you don't know whether or not the department's going to agree with you, whether it was a legitimate excuse. I mean, you certainly hope so, but so it's just, it's business reputation, ability to keep options on the table to avoid layoffs, potential running afoul of requirements if there's a subjective discussion of whether an exemption should have applied. And honestly, especially if you look at a scenario where a company over a 90-day period might have one layoff here, 2, 3, and then you're getting close to that, say 20, trying to keep track of that. And, when do you have to pull the trigger for your 45, 30-day notice? It's, there's just some practical issues with that. Those are just some of the concerns.
But it's not a public notification.
Yeah, well, it effectively is. I mean, the 30-day to the local, especially to the local, like,
But that's at the same time that you're notifying your employees, right?
yeah.
So, I think the thought is there an opportunity for the Agency of Commerce to come in and try to help if
Well,
they can? Then also notification to the department ahead of time so that they can gear up, making sure that they have everything ready to go in and assist those employees that are getting laid off. And I think all of that notice and everything needs to be kept confidential.
I'm not sure how formalized those rules are. I think one of the aspects of the current system where it's 45 days for the state before the more public facing notice is an attempt to address that.
Okay.
And if we're looking at just 25, you have a much lower threshold. And I apologize if I didn't make clear. I think the idea of what we're working with the department is that notice about a 25 would just be to the department. So that would, in order to address that potential concern about public. Yeah.
Unless it's, but I mean, if 25 represents 90% of the company, then maybe we want ACCD to know what's going on so that they might be able to come in and help, right? I mean, probably they've already been working with their RDC and.
Yeah, I mean, I don't think we discussed it specifically, but I don't think in principle, including ACCD as well, is necessarily an issue. So, I mean, we can certainly talk about that.
Maybe we need to look to make sure that what confidentiality, what we have on, make sure that things are kept confidential. I mean, I understand you don't want, a business doesn't want it out there, number one, for their competition. There's various reasons why they don't want their employees to know ahead of time because they can't afford to lose everybody. I mean, that would really kill the business real quick. So,
because often, I mean, and again, this is something addressed a little bit, but companies are usually not just sitting idle. And they're usually working very hard to avoid up to the last minute, avoid the layoffs.
so those areas we can look at too. So you can work with the department in those areas too, to see if we need to do more in that respect. Okay, Michael.
Just out of curiosity, is the 30 days notification to employees standard across the United States? Or is that?
No. Generally, the federal and a lot of the states, it's 60 days, but the thresholds are much higher to require notice. So that was that was part of the balancing, at the time Vermont was going to have a fairly low threshold. But we should have a slightly shorter notice, which would basically give more time to address stuff before you have to provide notice. So that was part of the give and take on things.
Just how much lower? Yeah, well, I can.
So yeah, I mean, generally, a lot of states have it's usually 50 or 25, and most of the states have it's a variation of, like, for example, one of the models we were looking at is I think there's about 4 states that have for a layoff. Layoff and closures can be different. For a layoff, it would be 25 people or 1/3 of the workforce, whichever is larger, which is about half of what the federal, or in terms of the number the federal folks have. And then again, most of those states have it's within a 30-day period, not a 90-day. There are 1 or 2 that have a 90. Maine actually has a 180-day. But if you start looking at the other states, sometimes it's only closures, it's only state notice. There's lots of little variations, and just taken as a whole, Vermont's already pretty sensitive, it would be a way to put it. And if we went down to 20, it would definitely be an outlier in many ways.
In Michael Harrington's memorandum for 117 from yesterday, there's a comparison table that gets into a bit of this information from different states.
Yeah, and I can, we put together a table for, I don't know if they developed their own independently, but I can get some comparison data if we want to develop, especially if down the road, if we want to look at a more thorough overhaul. So.
Question? Bill, thank you.
Thanks very much.
Continue conversation next week, and I think if we can touch base with you, Dirk, sometime next week, and figure out by the committee, and then circle back in. Anything else, committee, you want to do? Besides go home? Okay, any question? For next week, we start Kids Code on Tuesday, all day. And then Wednesday, we have a tariff hearing in the morning. More conversations in the afternoon. We're gonna start the TIF next Wednesday afternoon.
Oh,
And then we have another tourism hearing on Thursday morning. And I think continue on TIF Thursday afternoon after 4. And then Friday, I think we'll take another bit. And you can work on it. So everybody have a good weekend. Thank you for your work this week. Although it was much lighter than it was the week before.